May I extend my welcome on behalf of the Wallace Stegner Center for Land Resources and the Environment and for the University of Utah S.J. Quinney College of Law to this annual Wallace Stegner Lecture event, which kicks off our annual symposium, this year being the 20th anniversary of that symposium, and this year's topic being air quality, health, energy, and economics. And our lecture, as reflected in the title up here, ties directly into that. For those of you that don't know me, I'm Bob Kiter, the director of the Wallace Stegner Center, which I've had the pleasure of doing now for all of these 20 years. And it has been a true pleasure. Let me just begin by thanking our principal funders and our sponsors for the symposium and for the annual Stegner Lecture. Principal funding for the symposium comes to us from the R. Harold Burton Foundation, which was our founding donor and has been our principal donor for the last 20 years, since 1996. We also have received funding continuously for a number of years now from the Cultural Vision Fund, which supports not only the Stegner Center Symposium, but also our Young Scholar Program and our lecture series. Sponsors for this year's annual symposium include also the S.J. and Jesse E. Quinney Foundation, which I should note provided initial funding to really establish the Wallace Stegner Center here at the College of Law. The Nature Conservancy in Utah, the American Bar Association section of Environment, Energy, and Resources, and the Natural Resources Law Forum, all of whom provide important support for these events. Let me encourage you, if you have not already registered, to join us for the annual symposium, which kicks off tomorrow morning at the Rose Wagner Center for Performing Arts downtown on 3rd South. Brochures about the symposium are available on the tables outside. It's still possible to register either today here or tomorrow morning at the symposium. Let me also note an upcoming event, which is our annual Young Scholar Program. Professor Emily Hammond from George Washington University School of Law will be joining us. She'll deliver a downtown continuing legal education program at the Holland and Hart Law Firm on March 11th. More pertinent perhaps to this audience on the 12th, that is next Thursday. She will be here to deliver a lecture on risk and retroactivity in energy and environmental law. Again, there are flyers outside describing the program, and the Cultural Vision Fund has provided the initial and continuing funding to support this important Stegner Center program. Let me introduce Bob Percival, who's the Robert F. Stanton Professor of Law and the Director of the Environmental Law Program at the University of Maryland Carey School of Law. Bob has his undergraduate degree from Macalester College with honors, I should note, and his Juris Doctorate and a master's degree from Stanford University, where he was the managing editor on the Stanford Law Review and the Nathan Abbott Scholar, an award acknowledging his placement as #1 in his class at Stanford. Prior to joining the Maryland faculty, he served as a law clerk for Judge Shirley Huffstedler on the U.S. Circuit Court of Appeals for the Ninth Circuit, and he also had the privilege of clerking at the United States Supreme Court for Justice Byron White. He then served as a special assistant to the first U.S. Secretary of Education and as a senior attorney for the Environmental Defense Fund before entering academia. Since coming into academia, he has, among other things, written and edited the country's most widely used environmental law casebook, Environmental Regulation, Law, Science, and Policy. That's now in its 7th edition. That's long staying power for casebooks, Bob. He's got 100 publications that address environmental law, federalism, presidential powers, regulatory policy, and legal history. He's visited at Harvard Law School and Georgetown University Law Center. And most recently, he received the senior, that is this past year, Senior Distinguished Education Award from the IUCN, International Union for the Conservation of Nature, Academy of Environmental Law, in recognition of his outstanding teaching and contributions in the field of environmental law. With no further ado, please welcome Bob Percival.
I'm so fond of Utah from my childhood memories. I grew up in Des Moines, Iowa, and a couple of summers my parents would pack the 5 kids, the first time we were all under 10 years of age, in the back of a station wagon, drive out to southern Utah and camp out and just explore the wondrous beauty of southern Utah. And my father had this obsession with wanting to visit every national monument that had Native American ruins, and that was one of the things that really helped inspire me to love nature and want to get involved in environmental law. These days I'm doing a lot of work in China, where environmental conditions, as you may have heard, are very different than in the United States. Air quality at times there is off the charts in a really bad way, to the point where they're trying to invent new terms for it, post-apocalyptic. It's estimated by the World Health Organization that 1.2 million people die every year in China from exposure to air pollution. About several years ago, they estimated about 700,000. The Chinese government got offended and made WHO take that off their website. But now everyone realizes that, and the central government realizes that it's essential to make environmental protection a priority, so this can be openly discussed there. At times, they've had to shut down the airport because the pollution was so bad. When I last visited China, it was my 33rd trip there in last November, the pollution was so bad that you literally could not see the Beijing airport terminal from the runway. Now, you may have heard just in the last week, a former TV anchor in China, Chai Jing, has filmed her own documentary that she's put on YouTube about her own experience being pregnant for the first time and fearing for the health of her child because of environmental pollution in China. And this has gotten over 1 million hits within the first day or two. There are now 100 million. There are now something like 280 million comments about this on microblogs in China, and the government censors did not take it down. The brand new head of China's Ministry of Environmental Protection, Chen Jining, has praised her and said this might become the silent spring for China. So what I want to talk about today is why are things so bad in China, but we've been so much more successful, we still have problems, in pursuing clean air in the United States, and why the U.S. example is now something that's highly prized by the Chinese, to the point where President Obama and Xi Jinping, the Chinese leader, agreed in November on an unprecedented new climate agreement where for the very first time the Chinese have agreed to cap their greenhouse gas emissions. And what I want to emphasize as we look back over the history of efforts to protect air quality in the United States is that there have been several critical junctures when we made bold decisions in the face of people saying that what we were trying to do was impossible, the technology didn't exist. We chose clean air. And many times there have been what you might even describe as political miracles that have helped make this possible. Now, economists and political scientists have told us at times that it shouldn't be possible to have strong environmental protections because it involves an issue where you have concentrated costs on powerful industries in return for diffuse benefits, many of which are not realized for many, many years. And so the lobbies that are going to be most affected by regulation should be able to, in many cases, defeat, delay, or postpone regulation. That was the thesis of the late economist Mansur Olson, who at the University of Maryland, in The Logic of Collective Action. How have we been able to overcome this in the United States? Well, many people think environmental law was born in 1970 in the United States when we got our first major laws like the National Environmental Policy Act and the Clean Air Act, but it actually has a much longer history. Back a century ago, the Supreme Court heard within its original jurisdiction disputes between states over interstate pollution. We had generally inherited common law from England, where since the 17th century, at common law, you had a right to sue over a nuisance, anything that interfered with the quiet use or enjoyment of land. And in a famous case from the 17th century called Aldred's case, a British court had held that you didn't have to be a trespassory invasion in order for it to be actionable. If someone's pigsty smelled so badly that it destroyed your ability to sit out in your backyard at your country house, you could sue them for a private nuisance. In similar fashion, although from a different line of cases, the law of public nuisance arose. What used to be common law crimes, things like poaching in the King's Game Reserve, interfering with highways, was used by states back in the early 20th century to deal with severe pollution problems. And the first famous case was the Georgia versus Tennessee copper case, which was filed originally just after the turn of the century, where farmers in Georgia complained because all their crops had died as a result of the incredible pollution that was coming from a smelter that had absolutely no pollution controls because there was no technology to control the pollution from the smelters at the time. So Georgia, on their behalf, filed a public nuisance action in the U.S. Supreme Court, and after years of having evidence gathered in the case, the court, in a famous opinion by Justice Oliver Wendell Holmes, said states have the sovereign right to protect their citizens against air pollution, and that meant that the court could use its equitable power, something the Supreme Court rarely used, to actually issue an injunction. And the Supreme Court issued an air pollution control injunction that required the company to cut back on its production in a way that ultimately forced them to develop new pollution control technology, the lead-acid chamber method, which became the first technology to control sulfur pollution from smelters. Now, at the time, the copper industry in Tennessee, where the smelters were located, was the source of about over half of the economic livelihood of the communities. The Supreme Court didn't want to shut them down, so they didn't order the pollution completely halted. But what they did by requiring these production cutbacks is creating an incentive to look for new technology to control the pollution. As new technologies were invented, sometimes they weren't always environmentally benign in ways that we did not fully understand. Thomas Midgley was a famous chemist who had two marvelous discoveries for the time, chlorofluorocarbons and tetraethyl lead. Both were viewed at the time as major advances. CFCs greatly improved refrigeration technology that enabled food to be preserved and transported over larger distances. Tetraethyl lead cheaply boosted the octane of gasoline. It was only later that we realized how much destruction they were doing to our environment. In 1925, a controversy arose over the use of leaded gasoline, with Alice Hamilton, the first female professor at the Harvard School of Public Health, arguing that we should not allow lead additives to be put in gasoline because they inevitably would result in lead getting in the air and poisoning people. The Surgeon General recommended that a quick study be done where they compared the health of filling station attendants at stations that sold leaded gas with those that sold unleaded gas, found no difference, and said, well, this is a problem we have to monitor, but we'll let leaded gasoline be used. The result was, over several decades, tremendous increases in lead poisoning, particularly for those who were exposed near thoroughfares. Perhaps the worst pollution episode in the United States at the time occurred in October 1948, where, as a result of an inversion, a zinc company in Donora, Pennsylvania's emissions proved so toxic that day turned into night. 20 people died, thousands were taken to the hospital, and this helped spur greater environmental consciousness in the United States. There are two excellent books I wanted to recommend. Deborah Davis, who's from the area of Donora, Pennsylvania, has written this book, When Smoke Ran Like Water, that describes it in great detail. And Noga Morag Levine has a history of the use of the common law to respond to air pollution. In both cases, the law could respond after the fact when you had really big visible nuisances. But when you had something like lead poisoning, where the effects, which are generally neurological, aren't so apparent immediately, we had a hard time adopting preventative regulations. It still blows my mind that when I was a small child, back in the 1950s and the early 60s, here in Nevada, here close to Utah, in Nevada, the Nevada test site, some years we were engaged in such a nuclear arms race with the Soviet Union that we were exploding more than one nuclear explosion a week in the atmosphere. You could even see the mushroom clouds from the Las Vegas casinos. And one of the real heroes of environmental history are the scientists who started warning us that this was leading to an atmospheric buildup of strontium-90 and other radioactive substances, not just in Nevada or Utah, but all around the world. And that helped convince world leaders, President Kennedy and Nikita Khrushchev signed the Nuclear Test Ban Treaty in the early 1960s, where they at least agreed that testing would be done underground. Two other scientists who were heroes are Caltech's geochemist Claire Patterson, who did the studies during the 1960s that showed how much lead from leaded gasoline was getting into the air and the impact that was going to have on health. And Dr. Irving Selikoff of Mount Sinai Medical Center, the epidemiologist who did the first major study showing that hundreds of thousands of workers were dying as a result of exposure to asbestos, particularly during World War II in the shipyards. We all know our Silent Spring, which came out in the early 60s, was directed at the buildup of synthetic organic chemicals in our environment. This helped produce a mass movement that led to the first Earth Day. We just recently, and this is something that most people aren't aware of, had the 50th anniversary of President Lyndon Johnson being the first to take note of the possibility that the buildup of greenhouse gases was going to cause harm to the planet. He noted that this generation has altered the composition of the atmosphere on a global scale through radioactive materials and a steady increase in carbon dioxide from the burning of fossil fuels. Earth Day, April 22nd, 1970, mass movement, millions take to the streets to demand that Congress enact legislation to deal with environmental problems. I actually did not participate in the Earth Day demonstrations. I was in college. I was protesting the Vietnam War that day, so there were all kinds of things involved. In the run up to the 1972 presidential election, we had an unusual set of political circumstances where President Nixon thought that the rival candidate would be Senator Edmund Muskie, who was the chair of the Senate Environment Committee that was helping to draft some of this new legislation. So what you saw was actually a competition between the two to see who could be the greenest and propose the most radical environmental legislation. Most people don't realize this, but in his initial environmental message, President Richard Nixon proposed that we set a national goal to phase out the internal combustion engine within 10 years. When Al Gore later, decades later, in his book said maybe we should do that over 20 or 30 years, he was denounced as a radical. But at the time, in the late 60s and early 70s, that was not considered so radical. Richard Lazarus, a Harvard law professor, in his wonderful book, The Making of Environmental Law, goes into great detail about this history. And he notes that from Nixon's tapes and records, it's quite clear that he didn't have any personal passion for the environment. He just was doing this largely out of political necessity, and he turned around later and denounced the environmentalists in 1972, vetoed the Clean Water Act, but it was enacted by override of his vetoes. But the landmark law in the U.S. to help clean up our air was the Clean Air Act of 1970. It was radical in many respects. It required uniform national minimum standards for air quality. It directed that makers of automobiles would have to cut pollution from them by 90% within 5 years, or they could sell no more cars. For the first time, it established citizen suit provisions where ordinary citizens could sue not only violators of the environmental laws, but also agencies that failed to carry out the mandatory duties that they had under those laws. This was enacted despite cries of doom from the regulated community. The auto industry claimed that it was going to be totally impossible to come up with the technology to reduce their emissions by 90%. They talked about it shutting down the economy and the auto industry. There's this wonderful group that runs the Cry Wolf Project, which goes back and looks at some of the claims that were made. There's always this tendency for the regulated community to engage in strategic behavior when you're considering adopting regulations. You say horrible things will happen and exaggerate as much as possible in order to forestall yourself from being regulated. But once the regulations are adopted, American industry has proven to be incredibly creative at being able to come up with ways of developing new technologies. Now, another instance where there was sort of a miracle with respect to the Clean Air Act was the creation of what we now know as the PSD program for prevention of significant deterioration. The Sierra Club, focusing solely on the words in the very prefatory goals section of the Clean Air Act, that the purpose of Congress was to enhance and maintain air quality, argued that it was absolutely required that EPA establish a program to protect air quality in parts of the nation that already would meet the new National Ambient Air Quality Program standards. And they won in federal district court. The government appealed to the D.C. Circuit. The D.C. Circuit split evenly, which affirmed the decision below. It was then taken up by the U.S. Supreme Court. And I spent a couple of summers going through all the papers of the justices that became available when the late Justice Thurgood Marshall died, and then later when the late Justice Harry Blackmun died. And those papers revealed the Supreme Court originally had voted 5-3 that there would be that PSD was not required, that it wasn't explicitly in the statute, didn't have to be adopted. It was only because Justice Marshall at the last minute shifted his vote that meant that Justice Stewart's opinion saying EPA was not required to worry about areas where air quality was already healthy turned into a vote that comes out the opposite way, because if the court splits evenly, it keeps in place the decision below, which is the district court decision. So Justice Stewart sent around a memo saying, here's my new, much shorter version of my opinion, which is simply affirmed by an equally divided court. And that's how we initially got the PSD program, which is now such an essential part of the Clean Air Act, particularly as we talk about EPA's plans for greenhouse gas regulation. Now, ultimately, this was ratified in the 1977 amendments. In 1974, two scientists working on the environmental impact statement for the space shuttle, F. Sherwood Rowland and Mario Molina, came up with the theory that chlorofluorocarbons were so stable that if released into the air, they could make their way all the way to the upper atmosphere, where they would interact with the Earth's protective layer of ozone that protects us from ultraviolet radiation that would otherwise give us skin cancer, and destroy it. And that theory struck a chord with the American public, which started to realize for the first time, we really may be doing damage to our planet. The most ubiquitous use of CFCs at the time was as a propellant in spray aerosols. We used to all have the old spray-on deodorants, and the public just stopped buying them so dramatically that it was very easy for EPA to take the lead in banning these substances. And in fact, it then became a global movement that ultimately ended up in the 1987 Montreal Protocol, which has probably been the greatest success story for global environmental law. The nations of the world got together, agreed to phase out these harmful chemicals, and had the developing countries that had produced most of them phase them out first and most rapidly, followed later by the developing countries who got funds from a fund set up by a tax on CFCs. Now, perhaps, I think the most overlooked but most significant court decision ever with respect to the Clean Air Act was the Ethel Corporation decision by the DC Circuit in 1976. Tomorrow on the opening panel, I'm going to be talking about the lead in gasoline story and go into this in more detail. But basically, after a long struggle, EPA for the first time put limits on how much lead could be in gasoline. The lead industry sued and said you can't prove that leaded gasoline has harmed specific individuals. EPA said we don't have to. This is precautionary regulation. And initially, the regulations were struck down by a 2-to-1 vote of a 3-judge panel. The entire DC Circuit then took the case en banc, and by a single vote of 5-to-4 majority, the court said EPA doesn't have to have the same kind of proof you would need in an old common law lawsuit against someone that you claimed had harmed you. They're engaging in precautionary regulation. This endorsement of precautionary regulation is probably the strongest by any court in the United States, and it led to a very happy ending, as we'll discuss later. Then in 1981, when I was first starting out as a practicing environmental lawyer for the Environmental Defense Fund, I wanted to move back out west. I decided I was going to spend the rest of my life in California, where I'd gone to school and clerked for the Ninth Circuit. I got hired by the Berkeley office of the Environmental Defense Fund, and they said, why don't you stay in DC for a couple of years, because now that President Reagan's taken office, we're going to have a lot of litigation, because he at least campaigned against environmental regulation, famously said trees cause more pollution than automobiles. In fact, that led to a wonderful Greenpeace demonstration where they got a bunch of people to dress up in tree costumes, and they were holding signs saying, "Cut us down before we kill again." But one of the first things President Reagan did was that he appointed a task force on regulatory relief chaired by Vice President George H.W. Bush. And what this group did was they literally wrote to top business executives and said, which regulations do you want us to get rid of? And one of the ones that was most unpopular with the oil refiners was the limits on lead in gasoline. So they actually proposed, let's get rid of all limits on lead in gasoline. Despite the fact that it was quite clear that as more unleaded gasoline was being used so that it wouldn't poison the catalytic converters, lead levels in children's blood was dropping. The Reagan administration said, well, this is progress. That means we don't need those limits anymore. They were going to actually reverse that progress and say eventually everyone will drive cars with unleaded gasoline. Tomorrow I'll tell the story about some of the unusual coalition that helped defeat this, including conservative columnist George Will, who wrote a very influential column attacking the Reagan administration's proposals. Today he is demonizing environmentalists completely. I don't know why he changed. This is from the Wall Street Journal editorial board. They, when the Reagan administration had to back down on this, they accused the environmentalists of scare tactics, and they actually concluded their editorial by saying the worst thing is that the Reagan administration caved into the environmentalists, and that's very dangerous. Very popular host of Wall Street Week, Louis Rukeyser, said any restrictions on lead and gasoline are economically damaging and will produce no health gains. In 1990, what happened was really a political miracle. After 13 years of gridlock in Congress over things like whether we should have an acid rain program, President George H.W. Bush took office having campaigned that he wanted to be an environmental president. And Senator Byrd of West Virginia had been replaced as Senate Majority Leader by George Mitchell from Maine, from a state that was a victim of acid rain. The result was an amazing bipartisan consensus. Really, the last time this has happened in Congress on such a major piece of legislation. And I just wanted to play a little of this for you so you can hear his remarks upon signing.
America's heritage is precious. We will not turn our backs or look the other way. And that means polluters must pay. And so there is a new breeze blowing, a new current of concern for the environment. And today marks a great victory for the environment, the day when we have strengthened our clean air statutes, already the world's toughest. This legislation is not only in America's interest. Like so many of the environmental issues that we are working on, this bill is in the interest of people all over the world.
Consensus.
America's heritage is precious. We will not turn our...
Signed into law by a Republican president, despite the fact that several Nobel Prize-winning economists sent him a letter pleading with him to veto the legislation, saying it was going to harm the economy, it was unduly costly, and that many of the things that it expected industry to do just couldn't possibly be accomplished. That didn't end attacks on environmental legislation, though. During the Clinton administration, when EPA strengthened standards for ozone and particulates, as usual, it was subject to judicial review, and just about every argument in the kitchen sink that you could find was thrown in, and surprisingly, a conservative panel of the DC Circuit adopted a constitutional notion that the Clean Air Act violated the non-delegation doctrine because it wasn't specific enough about precisely where to set the standards, that Congress should specify what standards should be adopted. We all know today, given the prolonged legislative gridlock in Congress, what that would mean if everything had to be left up to Congress. Many people thought that the industry might get a sympathetic ear in the Supreme Court, but they were quite surprised at oral argument when, having made the argument that we can't live with a statute that gives EPA so much discretion, Chief Justice Rehnquist said, well, we've lived with it pretty well for 20 years, and the court unanimously rejected the challenge to the Clean Air Act. Now, what has this all produced? The U.S. has been amazingly successful in reducing air pollution. And we've done it while the economy has grown. Emissions of the 6 criteria air pollutants down 72% since 1970, while the economy's gross domestic product increased 219%. How costly has this been? When the 1990 amendments were adopted, the utility industry said, because it was going to require 10 million tons a year cuts in sulfur dioxide emissions, the utility industry said that this would cost $1,000 to $1,500 a ton. In fact, it costs less than $100 a ton to remove it. Studies that have been done of the costs and benefits of air pollution control have shown that the Clean Air Act and the 1990 amendments together have produced trillions of dollars in net benefits, and that they're increasing over time. Where do these benefits come from? From the fact that we've greatly reduced deaths due to exposure to air pollution, and reduced other types of diseases that limit people's mobility when they're to air pollution. So despite the fact that we were willing to make bold decisions in the face of cries of doom, has meant we have air that's clean today. But we still have important problems, and perhaps the number one is climate change. And there, the story is also kind of miraculous, at least from a legal standpoint. The nations of the world in June 1992 got together at the Rio Earth Summit and negotiated the UN Framework Convention on Climate Change, which set up the process for negotiating global limits on emissions of greenhouse gases. Now, I usually like to ask my audiences this question. You guys are so sophisticated that you'll have no trouble with it. Did the US ratify the UN Framework Convention on Climate Change? Robin's right. President George H.W. Bush went to Rio. He did water down some of the language in it and said, we don't want any specific goals now. He submitted it to the US Senate for ratification, and it was ratified unanimously in October 1992. Unanimously. Now that's something, we can't get anything ratified in the Senate today, whether it's against torturing children or whatever, or the law of the sea, unanimously ratified within months of being adopted. So we agreed to this process to set in motion global controls on climate change. December 1997, the Kyoto Protocols adopted. It was well understood at the time that just like we did with CFCs, the rich, developed countries that had caused most of the problem would be the ones who would do the first reductions. So the Kyoto Protocol only required developed countries to control their emissions of greenhouse gases. But it was well understood that as countries like China or India that are rapidly developing increase their emissions, they eventually would have to agree on controls. Article 3.1 of the Framework Convention used this concept of common but differentiated responsibilities to recognize that we were not requiring the developing world to control their emissions for now, but obviously we'd have to do it in the future. Now this is something most people don't remember either. September 2000, during the 2000 presidential election, George H.W. Bush is the Republican nominee. He's running against Al Gore, the great environmentalist. Fearful that that issue might hurt him, in September 2000, candidate Bush announces that if he's elected, he's going to get Congress to adopt new legislation to control emissions of carbon dioxide. Now, mind you, he rejects the Kyoto Protocol. He says, using the excuse that it doesn't require developing countries to do so right away, but he's promised to do this. So he then appoints Christy Todd Whitman, his EPA administrator. She immediately goes off to Trieste for a conference of the world's environment ministers where she's telling everyone, don't worry about Bush. He's good on the environment. He's pledged as part of his campaign that we'll regulate emissions of CO2 even if we don't do it through the Kyoto Protocol. She arrives back on March 13th and discovers that Vice President Cheney has secretly engineered Bush repudiating his pledge, and in fact, without even informing her, the U.S. President says we're not going to adopt any new controls on greenhouse gases. Then, the Bush administration made a huge strategic error that has redounded to the benefit of efforts to control greenhouse gases. And that is that during the Clinton administration, the EPA General Counsel, John Cannon, who now teaches at the University of Virginia, issued an opinion saying EPA did have the authority to regulate greenhouse gases under the Clean Air Act because they were pollutants that could endanger public health or welfare. As a result, in October 1999, Clinton, however, the Clinton administration said we don't have any intention of using that authority right now, but we do have it. October 1999, an obscure public interest group that few people were aware of files this petition saying, EPA, please regulate emissions of greenhouse gases under the Clean Air Act's provisions that deal with mobile sources. And as happens with most petitions to agencies, it just lays there, nothing happens. Bush administration takes over, and it wanted to put a stake through the heart of the notion that there was authority under the Clean Air Act to regulate greenhouse gas emissions. So what does it do? It revokes the old general counsel's opinion, replaces it with a new general counsel's opinion that says we don't have the authority. But they made one huge strategic additional error. They said that in order to show that we really are not going to do anything about greenhouse gas emissions, we are going to formally respond to that petition from October 1999 and deny it by saying, no, we don't have any authority. And secondly, even if we had the authority, we don't think we should use it because it doesn't make sense to regulate our greenhouse gas emissions when China and India aren't regulating theirs. Now, the reason that was such a huge strategic mistake is that it opened the courthouse door to the environmentalists. Having formally responded to the petition, they now could get judicial review. They took it to the DC Circuit, which voted 2-1 to uphold the EPA's failure to regulate greenhouse gas emissions. But surprisingly, the US Supreme Court took the case, and a decision that John Cannon has called Brown versus Board of Education for the Environment. The Supreme Court, by a 5-4 majority, held that EPA does have the authority to regulate greenhouse gas emissions under the Clean Air Act. That decision probably never would have come about had the Bush administration not been so eager and apparently so stupid to deny that petition. But what it did, even though the Bush administration delayed and didn't respond to the order from the court that it should reconsider its decision not to regulate them, it meant that when Bush left office and the Obama administration took over, EPA was able to make the endangerment finding, which triggers regulation under the Clean Air Act, and which has meant that you don't need any new congressional legislation. When Obama first took office, he made his top priority healthcare legislation. Another priority was getting new legislation from Congress to control greenhouse gases. That passed the House very narrowly, didn't make it through the Senate. Some have said that when you take over as president, you get to do one big thing, and that's essentially what Obama did. He wasn't able to do